king cake. Please do not choke on it. I do not wish you to be the reason we have to put warning labels on them in the future. My city of New Orleans thanks you for your cooperation. If you do find it, please let me know. My name is Jonathan Bailey, and this talk, as you probably have read by now, I'm assuming, is copyright and trademark for homeowners. This is, I think, a very important issue for the industry. One of the key things we are all doing is creating intellectual property, and one of the things we don't like to think about is intellectual property. So, like many things, it's time to put a little light on it. Now, we have a very, very full hour. I'm a little bit sweaty about this, because I usually get through one of the two topics in an hour. Now I have to get through two, plus do some haunty stuff. So, this is going to be fun. We're going to do this. We're going to do this. Quick synopsis, where we're going with this. What are we doing? What are we talking about? I have no idea if this is on, but I'm loud and obnoxious anyway, so I don't think it matters terribly. Can everyone hear me okay? Cool. All right, first off, we're going to talk a little bit about me, why I'm a narcissist. That's what narcissists do. Then we're going to talk about the basics of copyright. Makes sense. Then we're going to talk a little bit about the basics of trademark. Makes sense. If you're following along with the title, it shouldn't be a surprise. And then we're going to talk about how not to get sued, hopefully specifically some problem areas haunts typically run into when it comes to these issues, and how to avoid any litigation. And then finally, let's up on one thing. We're going to talk about how to protect your work. Then, after that, there will be Q&A, FAQ, TNA, ANA, AA, all that other stuff, plus king cake. So, hopefully, we're going to have a very, very good time with this talk. I'm going to try to keep it interesting and snazzy, and everyone, I hope, will enjoy it. Now, I think you know that I'm only going to be doing that 2 or 3 here in 1 moment. See, that's what you get when you don't get slide warnings me. Quickly about me, my haunt background is I do run a small haunt down in New Orleans, going back to Travel Sideshow. It's a home haunt that we are aiming to take professional in 2017. We've been operating it for 10 years. Love this industry, love everything about it to death, literally. I also co-host a podcast with the lovely Crystal, who is back there operating the DSLR camera, videotaping all this, entitled Haunt Weekly. It's at HAuNTweekly.com. And we also do haunt and horror and other related videos at GarbageHorror.com. But what brings me here today, as awkward as that is my day job. By day, I am a copyright and plagiarism consultant. What does that mean? It means I consult on copyright and plagiarism matters. Thank you, Your Honor. I have a blog that's been in operation for 10 years now, plagiarismtoday.com, and my consulting firm is copyright.com. Happy handouts, I have no idea. They will probably like the handouts from previous one mysteriously here about halfway through the talk, and that's A-okay. We will survive. One of the reasons why I think this topic is interesting, real fast, is anyone from Field of Screams here? Yes! I have been worried about that for a week. Actually, not really worried. It's a very well-known story. It's very interesting. I went to find interesting legal cases, sort of as examples for this. And this is probably the most relevant one I could find. Basically, Field of Screams, it is a haunt from Mountainville, Pennsylvania. It was founded in 1993. Very well-known national haunt. In 2009, they filed a lawsuit against another Field of Screams. Field of Screams opened in Onley, Maryland. Now, that's about 2 hours as the car goes. And they were claiming that people were confusing their Field of Screams for their Field of Screams. Now, to be clear, there are at least 24 haunts in the nation with the name Field of Screams. And this is an issue we're going to be getting to very shortly. Believe me. So they sued the Only Boys and Girls Community Sports Association, that's why I needed the notes, because that's a hell of a title, for $75,000 to cover legal costs and other expenses related to trademark infringement. The Maryland one countersued for $500,000. Long story short, as the one in Pennsylvania, the original one, by the way, I found it very fascinating. I didn't realize this when I took a screenshot, but if you look way up here, they're apparently still a little miffed about this whole thing. Now they put the whole giant, the original one location only stamp at the very top of their site. I didn't realize that until after I was reviewing this a couple nights ago. So very appropriate. But they attempted to pay the Boys and Girls Club basically $60,000 to change their name. They declined. And eventually, after 2 years, untold legal expenses, the case was dropped and went absolutely nowhere because the legal costs just got too flipping high for both sides. So both sides dropped the case. And that's kind of the nature of the beast here, is these types of situations are very expensive. Even a quote-unquote cheap copyright infringement lawsuit or a threat of one will run you at least 10 grand. You have to fight it at all. And for a lot of small haunts, that's a ticket to bankruptcy right there. If it continues on, it can be in the hundreds of thousands of dollars just in legal fees, hundreds of thousands of dollars in damages. So it pays to think about this a little. That's what I'm saying. So on that note, we're talking about the basics of copyright to start. Even though that case is a trademark case, we're going to talk about copyright first because that's the kind of home turf for me. Let's really quickly turn to the U.S. Copyright Office as they will elucidate us to what copyright is. It says, copyright is a form of protection provided by the laws of the United States, Title 17 U.S. Code, to authors of original works of art, which include literary, dramatic, musical, artistic, and certain other intellectual works. Raise your hand if that helped at all. Put your hand out. Don't lie. That didn't help me. That didn't help me. Okay, so let's take another approach. Let's talk about what copyright protects and the protections it provides. Let's talk about it kind of in two pieces. It's the best way to really cover this topic. What does copyright protect? Well, it protects works, creative works, fixed into a tangible medium of expression. Now, I see a lot of people taking notes. Let me give you an example of this. I'm sitting here, and we're going to ignore Miss Crystal back there videotaping this whole thing. I'm sitting here talking, the words pinging off these balls and disappearing into the ether. My words, minus all the recording going on, is not being fixed in any way. Therefore, I have no copyright over these words. But your notes that you're jotting down right now so eagerly, getting every single word, those are. Just because by the mere fact of taking something creative and putting it on something tangible, you're giving yourself copyright protection in that. Now, what does it protect? Just damn near everything, it feels like. Literary works, musical works, dramatic works, choreography, which I always found interesting. Pictorial graphic works that includes images, artwork, etc., etc. Motion pictures, i.e. movies, YouTubes, all that jazz. Sound recordings, and architectural drawings. And I forgot, by the way, on the slide about me, I forgot to give my usual disclaimer, which is I'm not a lawyer, I'm just a guy really intensely into this stuff. So, sorry, I forgot to do that, that's my fault. Moving on. Now, the thing about copyright that's interesting is that it's federally protected only. Since the 1970s, there have been no state copyrights. That makes it easier for us to talk about. You're going to notice the trademark part's a little thin. Why? It's also got some state elements to it, too. Turns out there's 50 of those. I know, I went to third grade. So basically, we don't have time to really go through everything in trademark interest, but we'll be able to do a fair amount on copyright. And the other thing that's interesting is copyright immediately transfers to the creator or his or her employer. Now, this is an important thing in the haunt industry. There is a very clear definition under the law who is an employee. I'm not going to get into employment law, but we all know that. If you were here for the previous talk, she talked about hiring freelancers and hiring outside consultants to do your web design. That's great, that's fine, but remember, they're not employees. Therefore, that copyright does not automatically transfer to you. Anything that is created by an outside freelancer or someone not actually an employee, even a volunteer or an actor in your haunt period, is not owned by you. So you have to be very careful to get those copyright transfers in order as you're doing this. It can be worked around, it can be dealt with. But believe me, it's much easier to talk about copyright with your outside contractors before you begin the work than it is to do so afterward when they have all the leverage in the world. does this copyright not protect? Turns out it doesn't protect damn near everything, despite my previous claim. It does not protect names. We're coming to that later on. That's in the trademark. It does not protect ideas. You do not get to sue J.K. Rowling because you had an idea about a book, about a boy wizard going to some magical school. That's not how this works. It has to be fixed into a tangible medium, but you then only get the expression of it, the actual part you put down. The idea itself is not copyrighted. That may be patentable, but that can be with a patent lawyer. We're not doing patent in this because screw you, that's why. Already only gave me an hour. Don't have enough time. It also does not apply to U.S. federal works. If it is created by a federal employee as part of their job, automatically copyright free in public domain. That's why you can use all the pretty photos from NASA you so desire. Anything made by that lovely Mars rover is also public domain, so Godspeed to you. Fashion designs. This is actually relevant in our industry. If you have a photograph of the cheap stock photo that I used for this slide, and you put it on a t-shirt or something else, that work can be copyrighted. It will be able to be copyrighted on a sheet of paper. It can be copyrighted. But the cut and the styling of your shirt, or your pants, or your dress, or whatever, cannot be copyrighted in the United States. And also, it does not apply to works without the requisite level of creativity. Your phone book, even though it took lots of people tons of time to make, just so you would have something to stop that squeaky door with, is not copyright protected. So think about that for a moment. Just because that's nothing but a collection of facts, i.e. name, phone number, and an untreated order, i.e. alphabetical. No creativity, no copyright. So what rights do you get when you hold a copyright? First one is to reproduce a work. That should make sense. It's kind of in the flipping name. Copyright. It makes sense that it be a right to copy. It just stands to reason. So, making the copies is one of your rights under copyright. So he's reading the subtitles. You're going to have a good presentation, sir. Another one, or several, prepare derivative works. J.K. Rowling, I don't want to pick on her incessantly just because she's an easy target. You always punch up in humor. When she wrote that first Harry Potter book, she was the only one who could go and create a sequel or license someone else to make a sequel. You can license and give permission to others, but they do so without your permission, that's copyright infringement. So when she wrote that first Harry Potter book, her right to make a sequel or license someone else to do it. Same goes for other types of derivative works. In our genre, you know, when the first Friday the 13th movie came out, the studio, they're the ones with the right to make the next one. It couldn't be like some guy in the basement going to make the sequel to Friday the 13th. If you're going to make a derivative work, you need permission from the original author. Yes, that does come up later in life. To distribute a work, to pass it out, this one is very relevant in the internet age. But it is very possible with streaming and interwebs and YouTubes and stuff like that, to distribute a work without making copies. So this right to distribute a work is incredibly important. And how do you distribute a work without making copies? For example, if you have something on YouTube or something that there's only one copy that exists that the public is accessible. Exactly. That public distribution. By the way, I should have added in the beginning, we're operating this presentation under third grade rules. If you have a question, feel free to raise your hand. Also, no spitballs. I don't make the rules, that's just film. So if you have a question, feel free to raise your hand. Okay, and I will call them. And finally, publicly display and perform a work. This one's really important in our industry. We publicly and display perform works all the flipping time. Music playing in your home is a public display and performance. You can videos you have waiting in the queue line, public display and performance. You need to be thinking about this. That is an exclusive right of the rights holder. There are a few limitations to copyright. Those limitations, primarily for us and our purpose, include fair use. I won't delve too deep into it, but I'll say this. Fair use is what is called an affirmative defense. The most common question anyone who talks copyright gets is this a fair use? Is this a fair use? Is this a fair use? And the answer is, if you're being honest, I don't know. I never. And the reason I never know be sued for it, go through all that hassle, all that expense, and then have a judge and or jury rule that it's a fair use. So, if you want to be the test case for something, that is completely fine. You can do that, but I do not encourage it, and I think for most of us, the main goal should be to avoid being sued, not necessarily be martyrs for fair use. That being said, 4 factors that a court will look at when determining what is and is not a fair use. First, is the purpose and the character of the use. Namely, what are you trying to do with it? Are you trying to create a new work? Are you trying to do it for commentary or criticism, like for a review? What are you trying to do with that work? The second is the nature of the copyright work. And that one's kind of gotten wonky in recent years. Basically, what that usually means is whether the work is published or unpublished. And in the age of the internet, all works are technically quote-unquote unpublished, but it's not a heavily weighted factor anymore. So don't worry too much about that one. Theoretically, though, unpublished works get more protection than published ones because the creator is supposed to get right first publication. But the internet's kind of screwed that one up a little bit. The amount and substantiality of the portion taken, I missed a that is annoying. Long story short there, taking 3 lines from a 10-line poem is very different than taking 3 lines from a novel. Think about it that way. If you're taking only small sections of the original work, small clips, a few seconds here or there, your chances of being fair use are way better than you're taking, let's say, 25, 50% of it. And finally, the effect of the use on the potential market. Basically, how is your use going to impact the original creator's ability to exploit and market that work? Are they going to be able to continue to go to the marketplace with it? Is it going to cause people to prefer your work over theirs, etc.? And the key focus here is it says potential market. If you take, like we'll say, an image from Friday the 13th and put it on a T-shirt, you can't turn around and say, well, they didn't make this T-shirt. They're not in that market. It's still a potential market for the original creator, and that's the important thing, is that potential market. And judges have a lot of leeway determining what is or is not a potential market, believe me. And of course, the other thing is copyrights do expire, contrary to popular belief. If it is a work of individual authorship, it is life of the author plus 7 years. For works of corporate creation, which a lot of this stuff, I'm assuming most people are at LLCs or some kind of corporate structure. In those cases, it's 95 years. So not much worry about your work expiring, and also, unfortunately, not much worry about not too many works you're going to be wanting to use in the public domain. There are exceptions, but not too many. So this brings us to the basics of trademark. Like I said, I'm going to kind of go through this one a little bit more quickly just because, like I said, there's a lot more complexity to trademark. Anyways, there's a lot more complexity to it, and there is a state element to it. So we will be reading through it, but still, we will talk about. Now, one interesting thing is, if you go to the U.S. Patent and Trademark Office, all their basics and trademark things are actually these really crappy 15-minute YouTube videos. They did like a fake newscast, so you couldn't get an easy quote. So I turned to the International Trademark Association for an unclarifying quote. A trademark is any word, name, symbol, or device, or a combination thereof, that identifies and distinguishes the source of goods of one party from those of another. Once again, I don't expect that to actually elucidate anyone. I'm just trying to have a little fun by pointing out how muddled these issues are. And making me feel sympathy for what I have to do 10 hours out of the day. This is my life, people. Welcome to my world. So let's do the same thing. What does it protect, and what protections does it provide? 2 parts, so let's give it a shot. What does the trademark protect? Okay, real fast. Let's have a quick chat about trademarks versus service marks. Technically, in this industry, we have service marks because we're providing a service, a content attraction. We do sell T-shirts, we do have things and products and goods, but our primary core business usually is a service. So what we consider is a service mark, not a trademark. That being said, I'm going to say trademark throughout the rest of this talk. I just don't want the one snooty guy in the back. The reason is the two are basically synonyms for each other, and many states don't even recognize service marks. So there's not much point. Pretty much you can always use trademark, and that's exactly what we're going to do, simplicity, avoid confusion. So, what does it detect? Letters and words, logos, pictures, slogans, colors, product and shape, sounds. Basically a lot of crap you can't protect underneath copyright. None of this, I mean, pictures would be, but colors, you can't copyright a color. Otherwise, Pan's going to be getting some mad licensing fees from all of us. I mean, dude. Seriously, you can't copyright colors, but you can trademark. And that's because trademark, as we'll see in a second, is a much more limited scope of protection than copyright, but a very, very specific form of protection. Now, the other thing that's interesting is trademark is both federal and state. There's a federal component. You can register and obtain a federal trademark. In fact, I'm going to assume, does pretty much everyone here have visitors from out of state come to their wants? With some regularity? I mean, my little rinky-dink con gets out of state visitors. I'm sure everyone else does too. So, then that means you qualify as having been in interstate commerce. Therefore, you can do a federal trademark. That's simple. It's completely your option. You can also register within your state. There are state level trademark registrations, but you also don't necessarily have to register at home. So here's the funny thing about trademark. No problem.
The difference between trademark and copyright.
Yes. Yep. Okay. A trademark basically represents the symbols and the things that you use to represent your business and your name. Whatever those may be. It could be the color scheme you use, it could be the logos, it could be anything that identifies who you are. Copyright applies to content you create, music, literary works, etc. Long and short of it is, the way I think of it is this. If I put out something and immediately makes me recall your business, that's a trademark. If I put something out there and it's meant to entertain, to enlighten, to be creative in some way, that's copyright. It's kind of a weird distinction, and you'll see there's a lot of overlap between the two. Like some logos, like some very artistic logos, can be copyrighted and trademarked at the same time. That's something we're going to get into in just a few minutes. And also in horror movies, horror characters like Jason, Freddy, Mike Myers and all that are both copyrighted and trademarked because they are copyrighted characters used in a copyrighted movie, but they're also trademarks in that they're t-shirts and they're trademarked and they represent the studio, they represent the studios. So I know it's a muddled answer, but it's because it's a muddled issue. There is overlap.
Good question.
Sure.
What if you want somebody to do
Yep.
and you all make sure they want somebody to take a 98 or 6 months.
Yeah.
If they come up with a regular speed,
Yeah.
and then another, you got to run a video, you do it for a couple of years.
Yeah.
They should have,
If they came up with, okay, I'm sorry. Basically, he's asking if you had an employee, you said employee very specifically.
Yes.
An employee work with you and present to you an idea while you were on the job, while you were brainstorming on the job, and then you do the idea for a few years. He came up with the idea previously, and then he splits. Does he have some kind of claim to it? And the answer is probably that he does not have a claim to charge you for example. I wouldn't say he could come back and give you up for a license because you were employing him at the time. You already paid your license fee. But that being said, he can technically, there's actually a recent case that dealt with exactly this. It's the MGA versus Mattel, which dealt with those really annoying Bratz dolls. It turned out the developer of Bratz worked at Mattel when he first came up with the idea. And he actually presented the idea to Mattel, and Mattel basically said, what are you, you're just some low jackass, get out of here. Get out of my office, Jenkins leave. And sent him home with a pat on his ass. Well, he went and pitched the idea to MGA. He'd come up with this idea at his own time. MGA said, we love it, they ran it, and then they created a doll line that somehow completely blew Barbie out of the water. And And so then Mattel sue and say, hey, that's our property. He came up with it, and presented to us first. And the courts ruled in favor of NGA. And NGA can continue to use it. So that's the story of it. If you had been using it for years already, so you adopted it, he doesn't have a right to come back. He performs, since an idea isn't copyrightable anyway, it's not something that you can really protect. But still, it's a good question nonetheless. Okay, logo would be different. You would own the logo. You would own it. It's probably copyrightable, and it's probably trademarkable too. Honestly, I'd have to look at the logo, but you probably hold both of them. Yeah, I'll come back to your case. We're not doing creative commons in this talk. I don't have enough time. I'll get with you afterward. We'll do this in the Q&A. Okay, now here's the thing about trademark that's really weird. We're getting kind of weird and obnoxious, and this is an industry that really needs this part of this talk. A copyright is a copyright is a copyright is a copyright. Every copyright is the same as the copyright next to it. They don't give you more or less rights. Trademark don't play that game. Trademark has the ladder of distinctiveness, which I put upside down for some reason on my slide. Don't ask me why. Basically, the more distinctive your trademark is, the better protected it is. Very, very, very important in this industry. So, let's talk about there are 5 tiers. I didn't count there, oh my God. Trademark protection to concern ourselves. First, our generic marks. These are the lowest. They receive absolutely no protection whatsoever. A couple of examples, Asplin and Thermos. Those actually were trademarks at one point, but they lost it through misuse of it over the years, and now they're the generic. Also, heroin. Heroin was actually a trademark at one point. Good luck marking that one, guys. Good luck. Heroin.
Because it's trademark, that's one of the reasons that in the early 20th century that they didn't understand what it was saying, and so doctors were amazed at how incredible morphine was at treating heroin. I'm not making that up.
He's right.
To treat heroin addiction, they thought they would.
Yep. Right. Then you have descriptive marks. These are marks that are merely descriptive. Things like quick-print and computer lab. That's a I'm with computers. I'm calling it computer lab. Basically, if all your trademark does is describe your business and what you're doing, it's considered a descriptive mark. This is the lowest form of protection there is with any protection. You have nothing, basically no, very, very limited protection here. Because a lot of businesses, for example, call themselves quick print. That's all over the place. I don't know how common computer land is. That was an example I pulled from a book. But apparently that was a thing in some way. Then you have suggestive marks, and no, these are not marks that are flirting with you. These are marks that suggest what it's about, but it's not just merely descriptive. Like PlayStation is suggestive. It suggests that this is something you play on, and it is a station for play. But you might not know immediately that it is a video game console, for example. Another one is Roach Motel. Okay, we know it's for roaches, but are we putting them up in a hotel of, oh, it's a roach trap? It's a little extra layer of ambiguity. Then there's arbitrary marks. Arbitrary marks are phrases and words that mean something, but don't mean anything in the context in which they are being used. The most commonly cited example is Apple computers. We all know what an Apple is, but what the hell is an Apple computer? Well, it's meaningless without the work and the good name and all the effort Apple has put into its brand. Another one that's similar, Ace bandages or Ace hardware. We all know what an Ace is, but it's kind of meaningless in the context of hardware or bandages without that extra brand stuff. And finally, and this is my favorite term on this slide, we have the fanciful trademarks, fanciful, which are completely meaningless without anything. That is confusion in the marketplace, so it does not prevent panic at this one. We all wish it. But no, confusion in the marketplace is a problem. If you have your haunt names, if I want to do a haunt review or something like that, I am free to copyright your trademarks and do a review. There's no trademark issue whatsoever. If I opened up a haunt 3 doors down to the same name, that's causing confusion because now when people say your haunt name, they don't know which one to go to. Obvious confusion. The use of a trademark is all about providing clarity in the marketplace. So if a use of it is somehow confusing, that is when we get into trademark infringement. And for the record, on the state level, there are oftentimes no such thing as trademark infringement. It's called things like unfair business practices, misappropriation, things like that. It's got a bunch of weird wonky names, but it's the same concept. We're misusing someone's trademark in a way they did not permit. Okay, never mind. Whoever is that child, so yes, it's all about that confusion in the marketplace. So, what are the elements of likely confusion? This sounds important, doesn't it? What are the factors courts weigh when determining whether or not someone has caused confusion? Well, first is the strength of the mark. Remember that ladder? Yeah, item 1. Each component or original marks, more just saying. Second is the proximity of the goods. This one's important in our industry because, like I said, going back to that Field of Screams case, there are at least 24 haunts called Field of Screams. You notice they only sued one, and it was the one that was a short car ride away. Those goods were considered close enough in their mind to warrant filing a lawsuit. The similarity of marks is also considered. How much alike are they? If I directly take the mark, that's different than if I use a mark that just kind of sounds similar. Like if I call mine Scream Fields in this Field Screams case, maybe mix it up a little bit. It could be different. Evidence of actual confusion is considered. That means, hey, you have someone who can talk to that was actually confused. Can you bring in that guy that drove to Maryland rather than one in Pennsylvania when they thought they were getting that? You bring that guy in court. Marketing channels used. This one is interesting for us because one haunt uses all radio ads or print ads, and one haunt is advertised exclusively on TV, for example. The marketing channels don't overlap. There's less likelihood of confusion. The type of goods and degree of care executed by the purchaser. This one is weird because the idea is this: when you're buying a pack of gum, you probably don't even read the label. You probably read the flavor. That's like 90% of the work, right? But when you're buying a car, you think about it a little more carefully. So the more carefully that person thinks about the branding, the more likely there is to be confusion, basically. The more important, certainly more important that confusion is. The defendant's intent in selecting and using the mark. Did he use the mark because he had some kind of legitimate claim? Going back to the Field of Screams case, the one that opened up in Maryland, the second one, they had what they call a Field of Dreams compound that it supported. The whole idea was they were doing a Field of Dreams sports complex. So when they wanted to do a haunted attraction to raise money for it, they called it Field of Screams. The intent wasn't necessarily to rip off the Field of Dreams in Pennsylvania. So that is weighed. And finally, the likelihood of expansion of product lines. This deals mostly with trademarks that are in different areas. So, for example, in our field, it might be a horror movie and a haunted attraction. There's pretty good likelihood a big horror movie won't expand into a haunted attraction. So, there's a likelihood of expansion into that product line. Therefore, the confusion is more likely. So, 7 areas of concern for us hunters. And I came up with a lot more, decided to pare it down to 7 because, like I said, we only got an hour and I'm already tired. So, long and short of it is, what are some things we need to be worried about in ways that we can be sued in this industry? Oh, so bloody easily. Well, I'm going to come out swinging on this one. And I'm sure this is going to piss a lot of people off, and that's okay. movie characters and movie scenes, and I see this at big haunts, I see this at the little haunts, I see this all over the place. The use of copyrighted and trademark characters in haunt is risky. Now here's the thing. I searched all over, I did not find a single case where any of the movie studios have filed a lawsuit against someone. Oh, you know one?
Yeah.
Oh.
There was one in Dallas where they had like 37 recruiters.
Oh, Jesus.
Yeah, the whole place seemed like rain was everywhere, and we might see this game show.
Yeah, no kidding, and that's one of the problems with my search is that I can only search litigation. So if there's a cease and desist like that never makes it to court, I know that's what I was about to say. That doesn't mean it didn't happen. I searched all over to find one that was shut down, but I could not, just because it's not in any Google records. It doesn't make it dangerous. That being said, come on, guys. We're a creative industry. We're better than this. We can create our own characters, our own themes, our own scenes. What are we doing? I mean, for me, it takes me out of the haunt when I see one of these. Oh, hi, Freddie.
On that end, so if you have stuff like from CSX or other manufacturers like that, do they own that character, or since they sold it to you, they apply and you can then use that character as your character? Say they do a custom paint job
Yeah.
or whatever.
There's something that's called an implied license. When you're selling a Halloween mask to kids, the implied license is different than a professional mask being sold at most of the haunted attractions. And I would assume that anytime you get sold a mask at that level, especially if there's an understanding you're going to use it in a capacity, that it'd be unreasonable for them not to. Just don't make copies of the mask. Please don't make copies of the mask. I don't want to hear about that. But yes, please, guys. And also, I think the one haunt that actually had the Jason mask on their merch. Not only did they have Jason in the haunt, they put it on the merch. Don't do that. Now we both infringe copyright and trademark at the same time, and you're basically begging the studio to come rain hellfire down upon you. You're on your knees asking for it at that point. Yes, the studios are not particularly litigious, but they will come upon you when they will get you. One of the reasons we have it is because we have such short seasons, it may be difficult for studios to find these uses. But as we get bigger, as we do more year round, as we grow, it's going to get more common. Watch me on this one. These are some very, very litigious companies. Universal, believe me, the protect their copyright extremely vigorous.
So one of the ones that I was under so when you movie Halloween,
Yeah.
you Shatner's face,
Yes.
but didn't.
Yeah.
So when they inverted the mask,
Yeah.
were they open? Were they safe? Was that very issue that?
I would argue in that case, what they did, what Halloween did, if I remember correctly, is asking about the use of the William Shatner mask in Halloween. They took the mask, if I remember correctly, they flipped it inside out and painted it dark white. At that point, I'd argue you transform the mask into a new one. You use it kind of as materials for something else. And not much of the original copyrighted work remains. So I think that one's probably okay, even if, we're not surprised if Shatner still took issue, because he takes issue with everything that Shatner does. Item 2, the haunt name and logo. I just put Sinister Visions up because they do great work, and I want to, help. I'm not saying they're bad people that infringe copyright or trademark. To be clear, not calling anybody out here. Your haunt name and logo, remember that ladder or distinctiveness? Get as high on the ladder as you can. The more distinctive, the more you can protect your name, the more control you have over it. However, be very careful that your name or logo is not too similar, especially to a haunt geographically close to you. I think last I checked, there were at least 28 haunts named Chamber of Horrors, including one in New Orleans. That's why I did the search. The point is, be original and make sure that if you're going to have similar haunt names, that at least they're far, far away, where there's no likelihood of confusion. Also, one tip, if you can't get the .com for your haunt name, you probably need to think of another name. Just do it, seriously. Music, oh my God, this one. Oh, music. I'm assuming we all play music inside our haunt, outside our haunt, everywhere else around the haunt. Music, music, music. License your music. Now, in the United States, we're kind of weird. Other countries don't do this. but we do not have a direct public performance right for sound recordings. And that's because sound recordings are a very, very bizarre area of copyright that I don't want to get into. It's going to take 3 weeks to even touch on that. But the compositions, meaning the part that's written down that makes the music, does. This is why cover songs have to be licensed. So if you perform music anywhere in your haunt, either A, get it from a source that you can license. Everyone knows who Midnight Syndicate is. Everyone knows their rules for it. But there are others that do the same or similar. That's one way. Or ASCAP, BMI, and CSAC. No, I'm not just being filthy mouth when I say the last one. Yeah, really, they're kind of all bad, aren't they? In their own unique ways. But those are the 3 organizations in the U.S. that handle licensing of music for public performance in a commercial environment. For a haunted attraction, it's not that much. It's maybe a couple hundred. Yes, anything in their catalog. These 3 pretty much. Exactly, it's nothing. It's nothing. It's next to nothing. Seriously. ASCAP, BMI, CSAC, unless you have like a mega haunt that gets hundreds of thousands of people, this fee's going to be like cheap as hell.
They actually searched this out and came and said you're in violation.
Yep.
And we weren't, because all we played was original stuff and they didn't even know. But we're like $18. Okay, great. Well, now I know what it is.
Yeah. You paid your ASCAP license, God, it's only the ASCAP library. ASCAP and BMI have there are two large libraries. And CSAC is kind of up and coming. Yes, I'm sorry, I wasn't ignoring you.
No, so you said that it was, I had ASCAP contact years ago.
Yeah.
And have no way. You said you contact these 3 individuals.
If you want to play, if you get all 3 of these, you pretty much can play any music you want, publicly in your home.
Who's the most expensive? Who's cheaper?
ASCAP and BMI are about the same, but the problem is they each have libraries. So if you get ASCAP, you have maybe 40% of the songs out there. If you get BMI, you probably have another 40%. And CSAC will give you the last 20.
You can look at the post
Huh?
You go on your financial zone or based on the
They base it upon usually the number of visitors you have estimated. Yes, it's based annually. He's asking if it's based seasonally, it's based annually. So, for example, if you were to own a restaurant, you would ask me how many people dine at your restaurant in an average week, and from that they would extrapolate to the year, and then they would charge a license fee based on that. And they do the same for bars and all that. So yeah, these are the 3 organizations. And like I said, for us, this is nothing. And ASCAP especially, the BMI2, do visit haunted attractions in order to not hit up those license fees. First,
He said something about that they had an original
yeah.
composition. You hired a musician who is also a little recording studio that we have. And he does something for you. That belongs to you.
Okay, if it's an original composition, yes, you can use it. But if you're doing covers of other music, or even like derivatives of other music, then you still need to get your ASCAP in line. Please, no. Get your ASCAP in line. I think I just came up with a slogan for him. I should trademark that now.
I had 2 more questions. One was, how do they audit the number? He must have $100 a year.
Yeah.
How do they audit that? You said about attendance. And
Yeah.
I've heard of any ones actually being on to verify that they having 10,000
The answer-
people, they come in to verify that some.
The answer to how they audit is,
They're just happy $100 and.
yeah. The answer to how they audit is they pretty much don't. They take your word for it usually. And because they do audit a certain number, but you have to realize ASCAP licenses to, I think, like something like over 1 million businesses. They don't have enough people to license it. And they're mainly focused on businesses that aren't paying any licensing fee. So they'll do like sanity check, like if they know that you have a haunt that's this size or a bar that's this size, they'll know you're not getting just 10 people a week. You know, they have sanity checks, but they're not the IRS, is what I'm saying. Thank God.
And I think another good point is, I've heard like, you hire a radio station,
Yeah.
tell them to do a remote answer station. You're not covered with this.
Yeah, that's correct.
You don't have a license.
That's correct.
Even though you just, radio station has a license, it doesn't. You bring it to your event, you're in violation.
That is correct.
I think it's a good point.
That is correct. And another thing is,
Can you touch on work for hire?
I'll get on that in just a moment. Yeah. With the radio station thing, that also applies to DJs. You have a DJ Wizzywack or whatever come out there and perform for your people. He's not responsible for licensing the music. You are.
If he's a contractor, you're supposed to.
Yes. Because the license applies to the venue, you run the venue. Okay.
And on top of that, live music, they're doing covers of,
Yep, same deal. Need a license. Seriously, guys, this is silly cheap and saves you so much headache. In all three cases, all you have to do, I wish my handout here, it's in the handout. But yet, all three cases, all you got to do is go on their sites, say, I'm a business, and fill out the form, and they will help you go through the motions and get it licensed. It's really simple, really easy, should not cost much money, and could cost you a big potential legal headache.
I don't know if you're going to treat this up, but in terms of like audio files, not necessarily music, but like, could you tell the difference between, say, a direct quote by a famous character, say, Freddy Krueger sang on versus using the Godzilla scream or along the Bill on the screen? Like, how those two treated?
Is it Bill or Will? I've heard both. I've heard both. I've heard both. I've heard both. He's asking about like sound clips, like Godzilla scream, a licensed character, etc. If it's something that short and that small, it's probably going to be a fair use anyway. It needs a license. But yeah, that's not something you can get or have to be minor. This is solely for music.
When you go see a movie with THX,
Yeah. Yeah, that is one of the rare cases where sound for trademark. Actually, it is. It's not common, but it does happen.
All right.
Well, somebody needs to do the Inception bomb as a trademark now. I think that should be the next one.
If you remember the Apple, Beatles formed the Apple
Yep.
in the 60s,
Yep.
they made an agreement with Steve Jobs and Apple Computers about never producing music, and so when Apple created that distinctive audio sound, the name of the file was specifically called So Soon.
Yeah.
Because that was the one they agreed not to, Apple Computers and promised not to make music, and that was their one exception.
Actually, it goes a little beyond that. He's talking about Apple and how they struck a deal with Apple Music to stay out of each other's way, Apple Computer, way back in the 60s, way back in the day. They actually ran control again when Apple was iTunes and got into the music industry. They had to work out a new channel. So it doesn't happen. Okay, your website and social media. You post text, you post images, you post videos, you post other stuff. Make sure either you created it or that it's appropriately licensed. One or the other. Either way, you're A-okay. I know a lot of us tend to farm out those duties to a staff member. Make sure that staff member knows what the hell's up. Because the staff member doesn't get sued. Never forget that. Merchandising. I could not think of another thing to put there, okay? Spaceballs, the flames are alive. Be doubly careful with anything on your merchandise. Remember that story I told you about the haunt with? Yeah, don't put anything that's trademarked or owned by other people on your merchandise. It's bad enough to commit copyright infringement and put it in your potential copyright infringement and put it in your haunt and put it on your site. But when you start selling it, that's when you go from a polite cease and desist to a, holy crap, I'm just go that high lawsuit. So that's when you're ramping it up. Be very careful with your merchandise and make sure everything in your merchandise is yours, which should be anyway, but that doesn't mean every haunt does that.
Question, so say if you have a, arcade section with Dutch games,
Yeah.
and then, Chuck E. Cheese,
Yeah.
toys, say you want to do like little Frank Krueger dolls,
Oh, yeah.
and you purchase those.
Yeah, that's-
awesome.
that's fine.
You get a license for it.
That's fine, that's fine. In that situation, you should be A-okay, because you're not implying that, you have a connection with Freddy Krueger, you're just not Freddy Krueger dolls. But if Freddy Krueger's the star of your haunt, or playing a big role in your haunt, you might be assuming there's a difference there. If it's just a doll you're selling at an arcade, that's different than having him as a major character, or even, a theme in the haunt. I think most people are going to be smart to recognize you bought a bunch of Freddy Krueger dolls, and they're giving away as prizes. I don't think that causes much confusion in the marketplace. Your marketing, TV, radio, print, and more, images, text, audio, and video. License it all, and by the way, do not necessarily put blind faith in whoever's putting it together. Ask them pointedly about this, because I do a lot of work protecting my main job, the copyright delivery consultant. My main line of business is verifying content originality and getting infringing material removed from the interwebs. The number one excuse I hear when I send a notice against the website is, oh, our website designer said it was okay. Or, oh, I had so-and-so do this and he said it was fine. Well, you used a bunch of text and images from your competitor. Jackass. Maybe you should Google what you're putting out there, before you use it. So market it. And I know we're running a little bit tight on time, I'm sorry. I'll warn you this, there is a big break after this, so I will stay here. I'll try to get through this in the hour so you can leave, but I will stay here as long as you need me, so feel free to use me all you want. Maybe I should have worded that differently. But still, I will be here as long as we need. Actors. Remember, your actors represent you. They are, even if they're not your employees, they are taking action on behalf of your company. You can get sued for what they do. If you tell them, no copyrighted characters, every haunt's got that one jackass. We all know who he is. One jackass that runs back, gets a Freddy Krueger mask, and goes out and does it anyway. Yeah, don't let him do that. That's bad. Okay, so real fast, I want to talk about protecting your work. We are in a creative industry. It makes sense to at least spend a couple minutes on protecting your work. First, register your trademark. As I said earlier, we all engage in interstate commerce. We all have out-of-town people come in. We are all eligible to do a federal U.S. patent trademark office registration. My advice, get a lawyer to do this, because it is very complicated to do, and there are maintenance requirements. You have to do these upkeep documents. I think the first one's at 5 years, and then one at like 6 to 9 years, and then 10 years after that, you have to do these maintenance documents. So get a lawyer who's well versed in it to get you started. Also, like I said, be sure to maintain it, keep it up. This will help you a great deal. Should that law open 3 doors down with the same name, or just another business with a very similar name. And I should also say trademarks, plural, because a lot of us have a company name and a haunt name that are separate. Register both. Take your time to register both. Register your copyrights. When you do videos, when you create music for your haunt, copyright.gov is the site. Register your copyrights. Please get on that. Now, here's the thing. Registering your trademark gives you extra protection. It helps. It's great. It's wonderful. You have it. Nice. Registering your copyright is actually a requirement to file a lawsuit. You have copyright protection in the work just by merely creating it. And you can take certain legal action. You can file takedown notices, you can do other things. If you want to sue someone, it needs to be registered. If you want to sue someone and get the big bucks, you got to register it timely. And timely means within 3 months of publication. So whenever you create it, you've got 3 months to go ahead and get it registered. Well, it's either 3 months before publication or before the infringement. But it turns out I'm not psychic and can't predict when the infringement will happen. So it's 3 months after publication.
You can do this ahead of time.
Yes, you can.
Start.
Yes. You can do it. In fact, you can do what's called pre-registration too if you want. Most people just wait until they've done it. This is because they have that 3 month window. Most people just wait and do it then. But you can pre-register and do it ahead of time. Do it whenever you got to finish work. Registering your copyright. I'll tell you this, if you do it yourself, it is either going to be $35 if you register a single work, if there's a simple registration, or $55 if you register a more complicated work. Like you do a CD with multiple tracks or something like that. More complicated registration gets a little more expensive. That being said, if you problem hire someone like me, for instance, do it for you, I charge about $100 for my time to do the registration. And I include people in copyright registration, but it's not very time consuming for you. And also, realistically, it's not that difficult. So,
So with that, right, you should recommend, let's say, write a story on it.
yeah.
You recommend copyright, so if something, you can put a cool story on it, and just copy it.
Yeah.
Do something on. They change some words around.
That's a derivative work, you still have it. Remember, the whole changing words around thing, that goes under derivative work. It's still an infringement. It's still one of your exclusive rights being infringed. So yeah, if someone changes just a few words around or something like that, doesn't make it derivative, doesn't make it
Involves
wrong.
the most of the content.
Yeah, exactly.
Obviously, derivative of what I mean. Story on it.
There's a term in copyright law about the heart of the work. If the heart of the work is intact, exactly. After all that, I encourage everyone to monitor their content, keep up to date on who is using it. Great free tool. Everyone should be using this in our industry, in every industry for that matter, called Google Alerts. It's google.com/alerts, predictably enough. Here's what I think you should have in there at a bare minimum. One is your haunt name. And if you need to, you can add your city or town too. That way you get only your haunt. That way you can see when people post reviews about you, when people say things about you, or a new search or a new listing comes up for you. Unique phrases from your content. Take a section of your front page text or your storyline or whatever. Pull out like, say, 6 to 9 words that's unique. Put it in quotes, stick it in a Google alert, and Google will let you know that content appears anywhere else on the internet. And then either you can get it shut down if it is infringing, or you can hire someone like me to do it. Either or. And also any relevant titles. If you do like a different theme every year, put your new themes in there too. You can also do images with Google. Images.google.com. I will take your logo and upload it. What you'll do is, when you go to images.google.com, there is a little camera icon in the search bar. You will click that, and you will upload your image, and it will find anything that matches it on the internet. So whoever used your logo for that purpose, you will find out. And just respond to any infringements as you deem fit. It was copyright and trademark stuff. Okay. We have a few minutes left in the hour, and like I said, I'm here until you guys are sick of me. So feel free to ask questions. I may be able to give answers. Also, to repeat king cake in the back. Has anyone found the baby? No. Bastards. Okay. Come on, let's get some questions going. What you got?
Just presentation available.
Yeah, I'll give you my card in a minute. I want to do more of those specifics. There may be a way you can get that domain vote. Yeah, it could be a problem. I have to look at the exact site what we're trying to do. There may be a approach. Oh yeah, that was see if I can get that taken care of. So,
Wait until we run out of space and we start talking.
We want to discuss that idea of the potential partners or whatnot, non-disclosure agreements,
non-disclosure agreements are expensive on what's in the agreement. Basically, non-disclosure and non-compete agreements, I kind of put them together, they kind of largely do the same thing. Basically deal with the sharing of information. So if you and I are talking about something to do with your business, and I go and I tell a competitor about it, you can sue me under that agreement. It's not really necessarily to do with copyright or trademark per se, but that could be any type of information. It could be just like financial information. Purely factual, no copyright, that's a business secret. So, yeah, it can deal with much more kinds of content.